Okay. Good morning.
Well,
I'm Mary. I'm Mary Jedry, and I'm here with an old buddy, Thomas Linzey. And I asked him to speak with me today because of a recent essay I wrote about how we might assert our sovereignty over all this federal overreach. So, Thomas, why don't you introduce yourself, please?
yeah, Mary, good to be with you today. My name is Thomas Lindsay, and I'm the senior legal counsel for an organization known as the Center for Democratic and Environmental Rights. And we work primarily on environmental protection issues, but in a prior life, I was the founder of the community rights movement, which in essence is about carving out local sovereignty to deal with environmental and other issues for communities to have some degree of self determination.
Okay, great. So you are also the co-author of a paper which I cited in my little essay, Phoenix from the Ashes. And it's a peer-reviewed paper at the Arizona Law Journal, I believe. Um, and in that, you write that regulation doesn't prevent harm, it manages harm. And for viewers new to this, how do you explain the difference between a regulatory fight and a rights-based fight?
Yeah, that was a fun piece to write. I wrote it with my colleague Dan Brannon, who works with us now on different issues and litigation here at the center. But yeah, so the history of the environmental movement in the United States is one built around this concept of regulatory law, that the power of government should be used to regulate how the environment is treated. And unfortunately, that history of regulatory activism in the United States around environmental protection hasn't really worked. And it hasn't worked for a number of reasons, including the fact that the current system of law treats nature and the environment basically as property that's being used by an owner, because we treat nature as capable of being owned. And so if you have a 10-acre piece of land and you hold the deed, it carries with it the right to use that property in basically any way that you see fit. And that right is protected by the Constitution and certain property rights that are ensconced within that constitutional framework. So when we fight within a regulatory regime, we usually end up in front of a judge arguing over some part of the regulations that govern the issuance of the permit for a particular thing or use, like fracking, for example. So, fracking project will be proposed, hydrofracking for natural gas, where they blow up the ground underneath to get at the tight gas and oil that's held within certain rock formations. And so a company will come in and say, we want to frack wells here. And of course, fracking has all kinds of negative ramifications, like affecting your well water or exploding faults underneath so that earthquakes are caused in Oklahoma and other places where fracking is done regularly. And so, assuming fracking is a bad and you don't want it, that the fracking company comes in and says, we're going to put in a frack well here. And you say, we don't want it. And the fracking company says, we don't care that you don't want it. And you say, well, we care and we don't want it. And the fracking company says, okay, well, fight it out over the permit that's being issued by the state agency to the fracking company. And when you end up in that kind of fight, you end up fighting under the rules that the oil and gas companies have established, usually decades ago, in writing the oil and gas laws for your particular state, and then writing the oil and gas regulations for your particular state as well. So what you find when you're in those hearings under a regulatory framework is that you're fighting under regulations that have already been written by someone else, and that someone else is the company or companies that are interested in exploiting your community for the oil and gas. So if we think that there's anything in those regulations or laws to help us to actually stop something, we're the crazy ones because we weren't the ones that wrote the regulations in the first place. And it's what I did for 10 years, which was track down environmental permits, read through them, figure them out, and then go in front of judges and argue that something was missing, like a signature or a bond amount, or some mistake was made in the permit. And generally, we would win those, but then we would be back at the drawing table the next day because the corporation would simply fill in whatever was missing from their permit and simply move forward with the project. So how is that different from a rights-based organizing model? Well, a rights-based organizing model would be in that situation around fracking that we recognize legally that people have a right to a sustainable energy system, or people have a right to the safety of their homes and the health of their families, that they actually have a legally enforceable civil right that can battle it out over the right claimed by the fracking company to come in and put the fracking well in. And right now, communities are stuck without those rights. We always think we have a right to clean air and clean water, but we don't. It's not set down anywhere in law that communities actually have a legally enforceable right to clean air and clean water. So, from my perspective, we have to create one. And the federal government, we can't work through our federal government to create one because the interests of the companies are run contrary to creation of those rights because it would impede that economic development that the companies want. So where are we going to actually find those rights and create them? And that's how we ended up with the community rights movement, which is communities claiming those rights for themselves through actually written law. So passing laws at the local level that actually recognize those legal rights to give communities a fighting chance when those corporations come in to do X, Y, and Z to their particular communities. And just to finish this part out is that part of the problem is not the lawmaking structure, because a lot of places and a lot of states have the ability for people to put stuff onto ballots and vote for it and vote it into law. And they don't have to go through their elected officials who are sometimes as contrary to putting rights-based stuff in as their congressman is. But it means seeing ourselves in a different way. We're always treated as the receivers of these policies, and we dare not even think about what it means for us to be in control or actually writing the rules. And our brains are always on the defense. What can we do on the defensive to try to stop these things from coming in? But we rarely think about ourselves as law drafters, law enforcers, or law adopters. But that's what ostensibly the best part of this country, the Declaration of Independence and the stuff that came with the American Revolution is based on, which is us being the final power of some kind, being we the people that have the power to actually draft these laws. And so part of the work over the last 20 years has been about helping people see themselves in that way. Because if people don't see themselves in that way, then you don't have the lawmaking, you don't have the self-determination, you don't have the local control that emerges. And so that's been a big challenge of the work over the past 20 years.
It's kind of like trained helplessness.
Yes. Yeah, there's actually a theory of learned helplessness. It's a psychiatric theory where you've been beaten up so many times that you decide that you're subordinate to the system that's beating you up. It's the same thing.
Yeah. One of the things I touched on was Dillon's rule, and that it's cast a long shadow over local democracy. And I wonder if you could explain what it is and why you argue it's fundamentally incompatible with the Constitution's commitment to self-governance.
Yeah, so it's one thing to make the law. It's a whole nother thing to actually get the law to stick. Because here you have small communities who are saying, look, we have a right to clean air and clean water, and your fracking or whatever else, factory hog farm, or whatever else you bring in here is going to violate that right. It's one thing to pass it. That's hard enough. It's hard enough for people to see themselves in a different way and then find help and draft the law and actually petition, put it on the ballot, and then get it passed. I mean, all that's a huge mechanism, a huge problem, obstacles, all kinds of things in the way. But then getting the law to stick after it's passed, to actually enforce it. So it doesn't just sit on the shelf, but actually enable it, weaponize it, enforce it, pick your verb, is something that has its own obstacles. And those obstacles have been very carefully constructed over the past 100 years by the entities that you're trying to enforce the rights against. And so when you mentioned Dillon's rule, that's one of the hurdles. And when we have conversations with communities, there are basically three hurdles. One is something called Dillon's rule. Nobody's ever heard of it, but it's called Dillon's rule. The second one is called preemption. And the third one is called corporate constitutional rights. So the way to think about this is there are three areas of law that have been carefully developed to stop you from taking the law that you've passed and actually enforcing it against those entities to make it real. Because you can pass a law, but it's not real until you actually enforce it and it has some practical application to stopping something. So what are those three areas of law? Well, one, as you mentioned, is Dillon's rule, and Dillon's rule is this whacked out legal concept that a municipality or a community doesn't have the power to make a specific law unless the state legislature has given it the specific power to make that law. So
Right.
basically, a community as a wholly held subsidiary of the state government, that you can't do anything at the local level unless the state government has told you you can. So you can't pass a weed pulling ordinance, for example, unless the state legislature has passed a state law that says you can pass a weed pulling ordinance. It's kind of crazy, but it's a wholly owned subsidiary kind of view. And it's on the flip side of the nickel from the second area of law, which is preemption, where the state steps in preemptively and says you can't pass this particular law. So Dillon's rule is you can't pass it unless the legislature says you specifically can. Preemption is the power that they reserve to overturn whatever you attempt to pass at the local level. And then the third one is corporate constitutional rights, where corporations have certain constitutional rights that you may be violating by passing and enforcing that particular law. So, for example, if you're banning fracking, the companies say, well, we have a permit to do the fracking. That permit is property. You're stripping our property without paying us for it. That's a constitutional right embedded in the Fifth Amendment property ownership protections of the Constitution. So we think we live in a democracy, but when it really comes down to it, extremely difficult to do the things that we need to do to claim that democracy, because passing stuff is so difficult and enforcing stuff is so difficult that we live in a system that's really difficult to call it a democracy, even though you can't see these things operating until you actually pull the tail on the pig, because it's when you actually attempt to do something that you run into these things.
What's interesting to me about Dillon's rule is it's not written into the Constitution. It's not codified as law. It's just sort of a concept that they've used. It has been argued up at the Supreme Court level, so I guess that gives it some meat, perhaps. But
Yeah, what's interesting about these three doctrines is that none of them are written in the text of the Constitution. So Dillon's
right,
rule is a purely judicial. The court said this exists.
yeah,
Preemption, most people would be amazed to know, does not exist in the Constitution. A preemption by the federal government over the states exists, but the preemption by the federal or states over the local is not in the text of the Constitution. And corporate constitutional rights, of course, had to be invented in the 1880s by the
right.
court. So none of that's in the text. It's all been about judicial activism and corporations pushing to get those theories into law.
In your paper, you tied community self-governance back to the colonial assemblies and the Declaration of Independence. And why do you see that as the real constitutional foundation of community rights?
Yeah, so people tend to equate the Declaration of Independence with the Constitution, and they're really two different kind of documents, and they grow out of two different time periods. So the Declaration of Independence was really a revolutionary red meat kind of, let's go, this is the new theory of government, which really wasn't new at all, but the new theory of government, that we are the government, the European powers laughed at us when the Declaration of Independence came out, because they said, how crazy is that? They had, you know, emperors that were chosen by God, and yet here was Jefferson and the motley crew saying, we don't have emperors. We are the people are the end governing authority. And that was kind of crazy to the European powers. But that document said that when government stops working for the interests of the majority, that the majority have the innate authority and power to abolish that system and put a new system into place. That's basically what the Declaration of Independence says, is that we're the end source as to whether these laws are legitimate or not. And if they are not, then we have the power to actually get rid of them. The Constitution was different. The Constitution was kind of the result of a counter revolution led by folks in the new United States who were the property and commerce guys. You know,
Right.
the Hancocks who were the exporter importers, and the George Washingtons George was the biggest landowner in Appalachia. He owned 63,000 acres of land and was trying to develop that and get government to pay for that development. So this new breed of kind of elite that wanted to tamp down the energies of the American Revolution were the ones that wrote the Constitution. It's a completely different document. And the Constitution was really about checks and balances between different levels of government, not so much about democratic authority or control. So if you're looking for democratic authority and control, it's the Declaration of Independence that you put your feet on. So when the suffragists did their work in the 1800s, they planted their feet on the Declaration of Independence because the Constitution didn't recognize women as anything other than property, basically.
Right.
And when the abolitionists planted their feet in the 1800s against slavery, they couldn't find a place to do it because the Constitution actually authorizes slavery. It has provisions dealing with state governments putting down slave revolts. It has the 3/5 clause of a person for slaves.
Yes.
It has
Right.
various pieces in it that actually authorize slavery. The abolitionists couldn't put their feet in the Constitution because it authorized and validated slavery. They had to put their feet in the Declaration of Independence. I think we have to choose. The Constitution is an anti-democratic document. It has other stuff in
Yes.
it about commerce overriding the power of people to make laws, and it's corporate constitutional rights are, of course, now ensconced in that federal constitutional document. So the real question is, what are we going to do about all of this stuff? We have a system of government that's anti-democratic. The Declaration of Independence is not recognized as binding law within the United States. That also surprises people. So when you pull it into courts, they say, well, that's not binding law. That's just a resolution. The Constitution is the only binding law that counts. I think we're at a place where we need to be thinking about how do we change that source code, the Constitution itself, whether amending it or rewriting it, whatever that means. But we tend to have a different kind of problem, is that we're always fighting on the defense with our fists on the front lines. We have very little time to step back and think about, instead of fighting these things on the front lines, how do we change the rules so that we don't have to be on the front lines all the time?
Yeah. Just
It's
change the playing field
absolutely,
altogether.
yeah, and the corporations do it all the time. They're always changing they're always changing the playing field, but we, for some reason, don't. And it's mostly
Yeah.
because all of our time and energy is taken up trying to not make things worse and being on the front lines trying to do that. And so I think the community rights movement has to be embedded in that Declaration of Independence language because it is amazing stuff when you read it. Constitution, not so much, because even though we extol it and celebrate it and worship it, it's not the document that we think it is. And it's actually causing us a lot of problems as we actually try to protect the things that we want to protect.
I've actually submitted on Substack notes and on Facebook a sample new Bill of Rights, just to get people thinking, about how else we might, like, really enact some changes. And in a way, I feel at this moment in time, with Trump dismantling everything, that instead of looking at how do we repair it and go back to normal, that we should like envision a whole different system. Take advantage. He's doing the hard work for us in that one regard, and now the real work is for us to identify what we want our democracy to actually be. And if they're going to break stuff, then let's build it back different. You've said that rights-based ordinances will inevitably be challenged and struck down until the Supreme Court takes them up. I'm aware of several of these ordinances. I attempted one myself. What kinds of ordinances or communities do you think are most likely to be the test cases? And what role do you see the ordinary citizens in building this test case momentum outside of lawyers and courts?
Yeah, so I think, and you have innate experience with this, intimate experience with it, but I think the communities that are the ones that are going to do the work are the ones that are impacted the most by specific projects coming in.
Yeah,
So basically, resource extraction zones, communities that are facing upfront, real extraction, exploitation, all the kind of stuff that's increasingly ramping up now. And those places are the ones that are going to do it. Increasingly, also, because I think there have been those communities rising up. But I think indigenous communities are really a place where this is starting to accelerate and pick up speed. So these are tribal communities that are thinking about different ways to use tribal rights, tribal sovereignty, because tribal governments in the US sit on a different level than municipalities. So it makes it a lot more difficult for the system to crash down on them as they do with municipal governments. So tribal governments have some degree of separation from that federal system that usually stops municipalities from moving in this direction. And plus tribal governments have courts of their own. So when you're trying things in tribal courts, there's a different flavor to it than what you get in Western federal courts, for example. They're usually striking these things down. And plus, tribes can change their legal systems fairly easily. So eliminating
right.
corporate rights, for example. I mean, there's a lot of leeway in there. So I think that's an undiscovered area of activism that I think is something we're going to be seeing more and more of in the future. And the biggest thing is that when tribes pass rights-based laws around nature, at least, so recognizing that ecosystems have certain rights, for example, that they can enforce those laws outside of reservation boundaries. So against states that are issuing permits that affect the river upstream, for example, it gives them an
Right.
oar in the water, a leverage point to do that kind of work. So I think that's one place where we're going to see more and more of that. But I also have to say, in my 30 years of practice, 30 years, over 30 years of practice now, that I've kind of given up hope on the courts themselves to do anything.
Yeah.
That there's kind of, we talk about the U.S. Supreme Court. The U.S. Supreme Court is probably never going to put their stamp of approval on any kind of local self-determination, local sovereignty stuff. So we need to think beyond that system and think to ourselves about what constitutional rewrite looks like, or bringing it closer to home. What does state constitutional rewrite look like? What if 100 communities in Oregon decided to do community rights work and then push that upwards to that, or to changing the Oregon state constitution or the Washington state constitution or wherever these communities are located, and begin to
Right.
change those state constitutions in ways that directly challenge the federal constitutional doctrines? That's all very fascinating stuff. It's almost like the ordinance passage is a training ground to find those people and communities who are going to eventually move forward to rewrite those state constitutional constructs. And the only thing stopping that from happening right now is resources. We've always had the ability to pick a fight here or pick a fight there, but never enough resources to basically bring folks together across different issue areas, which is what has to happen. It can't just be environmental. It's got to be public safety. It's got to be,
Right. Right.
rent control and right to minimum wage increases. It's got to be all that stuff brought together at some point to be the push that
Right.
eventually rises up to write a new governing document, I think.
So that's a great pivot point. My 140-pound mastiff is moving my chair here. Sorry. um, so you've touched on the fact that it needs to broaden, and I think that's the point of my paper that I wrote recently. Really, and I see like Illinois or um, Pittsburgh and so forth. They're or Chicago, and they're threatening, trying to assert some local sovereignty over this threat of Trump bringing in national force, National Guard, or ultimately the Marine Corps, and I feel like, and I bring it back to me, this feels like a concept that we could apply to common sense gun control laws. Our children have a right to go to school and not be murdered. I mean, that's a fundamental right. I I don't think I really got into this very well, but earlier with you, but I feel like people confuse fundamental rights with granted rights versus even privileges. And I've had some pretty heated debates about whether gun rights are an actual right or a privilege. I was at a meeting once where a woman stood up and said, "The Second Amendment is a right granted to us by God." And so, but maybe you could expound on what really the difference between a fundamental right, things that are unenumerated within the Constitution even, but are fundamental, versus granted rights and privilege.
Yeah, unfortunately, the lines are pretty squishy there. But fundamental rights are generally ones that can't be stripped, so they don't need to be stated anywhere. They're fundamental, and the
Yeah.
squishy part comes is that the Bill of Rights attempted to set down into text some fundamental rights. So fundamental rights that people had by virtue of English common law, or by the history of England, the unwritten Constitution, basically fundamental rights that they believed came from God, and they were set down into the text of these different documents. That they don't change their status by being put into the text. They're still fundamental rights, but because they're put into text, then there's some squishiness about whether these are stated and granted or whether they
Right.
whatever. The Second Amendment stuff is fascinating to me because, first of all, the Supreme Court jurisprudence has wandered so far from the actual text of the Second Amendment, which talks about well-regulated militias and the gun ownership in the context of a militia, and that's kind of the departure point between the 1960s Supreme Court, 1960s, 1970s, and today's, is that the law changes whenever they want to change it. And so interpretation of the law has become different. But when you read the plain text of the Second Amendment, pretty clear it's not about individual ownership of guns apart from that well-regulated militia piece. But leaving that aside, the fact is that there's never really been a movement in the U.S. to contest those Second Amendment contours with a clearly distinguished right to public safety or a right to school safety or whatever. And in fact, governments, municipal governments who have been trying to regulate gun ownership haven't even really been moving that direction of a right. So, I'd be happy if we just had a right battling a right, but we don't get that. We get a regulation battling a constitutional right. We really need to elevate community lawmaking to recognize a right.
Yeah.
And I think you can trace right to public health and safety back to being a fundamental right embedded in due process and equal protection, some of the other fundamental stuff. The gun ownership stuff is about ownership of property, basically. And even the current Supreme Court has recognized that property ownership is not a fundamental right. That comes as a surprise to a lot of people, but property ownership itself, the right to own a certain kind of property, is not a fundamental right, even according to our current U.S. Supreme Court. And
Right.
so the fact is, we need to level the playing field somehow, and then overcome certain property ownership interests with a right to public health and safety at the local level. I'm still not aware of any communities actually doing that. We've had bits and pieces over the years of places that have talked about beginning it, but nobody that's really taken it on seriously.
So, in your view, Where should we draw the line between fundamental rights that cannot be infringed, life, liberty, safety, and privileges that can be conditioned or restricted? I mean, you've touched on that just now, but I feel like um, given that the statistics in this country are so astronomically aberrant compared to other countries that take actual steps, Australia, New Zealand, they all took radical steps when a mass shooting occurred. And here it's just, another Friday.
Yeah.
And I feel like, I know this is not your bailiwick, but I feel like there's got to be some legal minds out there that can look at it from this concept, that communities do have a right to say we don't want AR-15s, uh, you know, in this community. And I don't want to get into a whole gun thing. I mean, I grew up with guns. I used to do reloads instead of washing dishes. I had to reload reload shotguns and rifle shells. That was my chore. And but I feel like there's an opportunity here if we just shift our thinking, which is what you talked about earlier, and stop seeing it as just shift the arena, just change the arena altogether, rewrite the rules, I suppose. So
Yeah, I mean, I grew up in a rural area as well. The first day of deer season was a holiday for where I grew up. Yeah, it wasn't
yeah,
like people were pulling out machine guns to take down a buck.
a deer. Yeah,
Yeah, I mean, it was
yeah.
just like there's just a different understanding of kind of use of guns in rural areas than with what we're seeing today. But I think there's a more basic problem, which is that the lawyers are the problem. We lawyers, as officers of the court, as what's embedded in our head, is that we're not going to advise a community to do something that's going to get struck down, and then the community is going to be held for legal liability and damages and other things from the gun corporations or from the gun owners in the community. And so that Second Amendment issue of a constitutional right becomes very powerful because you have very few lawyers who are willing to go against the grain and actually
Yeah.
be movement or advocacy lawyers, which we lack. There's so few. And then you have the problem that the progressive, just for a moment using the word progressive, the progressive kind of wing lacks intellectual rigor. It's like there's, we have the Brookings Institute and a couple of the think tanks, but the think tanks on the right wing side, the very conservative, reactionary side, far outweigh what can be done on the progressive end of things. It's just over the last 30 years, I've been reminded that in the progressive community, they lack an intellectual rigor. It's like rewriting the Constitution. When you raise it at certain meetings, everybody's just aghast. They're like, oh my God, we can't do that. We can't do that. It would be so bad. It would be so messy. I'm like, okay, well, then keep doing what you've done for the past 30 years and let's see where
Is
you end
it?
up
Yeah,
in the next 10.
yeah,
It's like,
yeah.
but there's a fear. There's fear that runs through everything. There's a lack of intellectual rigor, especially in environmental legal circles, about people trying new things, forget about it. It's like that existing industry of pumping out those lawyers and those groups. It's farcical. It's farcical where we are after 30 years of environmental activism that has produced almost zilch in terms of real environmental improvement. So you have to crawl through a bunch of different layers to find the place that's going to do what you're talking about. And then to have the advice given to them that's not just steering them right down the rabbit hole towards getting destroyed again as we have over the past 30 years.
So, basically, as a call to action, you've often said rights are not granted from above, but claimed from below, which is what we're talking about. And I think we've really kind of gone through this, but my question was going to be, what does that look like for a community that feels powerless, and where should they start? And then if you had to add one piece of advice to people watching who feel trapped in the regulatory process and doomed to lose, what would you tell them about claiming their right to self-govern?
Yeah, I'll start with that second piece first, which is just do it. It's like borrowing from Nike. It's to like just do it and don't and ignore all the important people that tell you you can't. Ignore the
Yeah,
lawyers, ignore the professors, the law professors who sit and never do anything in the ivory
yeah,
towers. Forget what the judges say. Just ignore it and just do what you know and think is right. I mean, the question on the gun violence stuff is how bad does it have to get before
I
there's
know.
a revolt of
Yeah,
some kind by
yeah,
municipalities? Maybe Minneapolis, maybe the Minneapolis City Council will begin to move in the right direction, but they're surrounded by all this bad advice. And so
yeah,
it's like you got to pierce through that and to be able to do anything because the kind of change that we're talking about is pretty paradigm shifting. So that's
yeah,
kind of the advice, and I think you will see over the next couple of years as things get worse from here, you will see pockets arising. It's just important that we are intellectually sound, that there are thinkers thinking through this stuff on a daily basis and throwing out new options. I mean, the Trump administration is great at it. They have they have folks throwing stuff out every day and thinking about
yeah,
how do we collapse this administrative state of ours and how do we,
yeah,
they're doing the thinking, the moving, the everybody else on the defense. It's working very well for them. The question is how do we kind of borrow some of the same tools and begin moving in the direction that we know we need to move? Because whether it's climate change or public safety or environmental issues or who's fracking who, I mean, eventually it's got to give. We're in a place with finite resources, finite everything, and so at some point something's got to give, and there needs to be a revolution, whether velvet gloved or whatever it looks like, but there has to be a revolution in thought and action. And people need to just stop listening to those experts that have put them in the place where they are now, starting 30 years ago.
the old axiom, you can't solve a problem with the same thinking that created it. Yeah.
Absolutely. Yeah.
So, I really am grateful to you for taking the time. I think we've gone over a little longer than you expected. Um, but I think that's our work now is to envision and imagine what things should be and then just look at the goal and not worry about how we get there
Yeah.
so,
No,
so
I agree.
much.
I agree. It's time to start dusting off the old, instincts. And people aren't stupid. They're the experts in their own communities about what works and what doesn't. It's time to throw
Right.
off those other layers and understand that we need to return to that original intent. Because after all, we did it before. In
Yeah.
fact, we did it before with weapons and fighting off the world's largest army and navy. It's like, we're not talking about going there, but we're talking about using the same kind of energy and instincts that we have to understand that we need to remake this place in our own image because the other side is remaking it in theirs. And
Yeah.
so we're
Yeah.
behind the eight ball now and we need to catch up.
Yeah. Absolutely. Hey, thank you so very, very much. I'll send you a link when I get this done. And this has been Mary talking with Thomas Linzey.